Hello and welcome to this recording about attorneys under lasting powers acting as trustees. I'm Barbara Gardner from Technical Connection. This is actually a question that comes quite often. And the question is, if a settlor has made a lasting power of attorney, can the attorney under the power exercise the powers of the donor acting as trustees? So the scenario is that an individual has usually settled his own trust. He's one of the trustees, and he also has appointed an attorney under a lasting power. And then the question is, can the attorney step into the donor's shoes, into those trustees' shoes, and exercise the powers of the trustee? To start with, it's important to say that what we're talking about today is subject to the law of England and Wales. There are different rules that apply in Scotland. Well, the general rule is that an attorney under a power cannot act as trustee, basically cannot step into the trustee's shoes. And there's a very straightforward and simple reason for this. The lasting powers are dealt with the Mental Capacity Act 2005, and this act provides that an attorney has power over the donor's estate. So it's important to know what a donor's estate is, and obviously this is estate. These are the assets that belong to donor in the donor's personal capacity. So a trust estate, which is the assets held in trust, are not the same as donor's estate. So basically, the rule is that an attorney cannot step into the trustee's shoes under the power. Now, there are, however, two specific exceptions to this rule, and this relates to delegation of powers. There are two possible scenarios. First of all, there is Section 25 of the Trustee Act 1925, which allows a trustee to delegate trustee functions for a period not exceeding 12 months. To do this, you need to execute a special power of attorney in specific words, and the period must not be more than 12 months. Obviously, in order to execute such a power, the trustee, who will be the donor of the power, still must have capacity to do this. Now, there is the second exception to the rule, which is that an attorney can exercise a trustee function of the donor if it relates to land or the capital proceeds or income from land in which the donor has a beneficial interest. This is provided for in Section 1.1 of the Trustee Delegation Act 1999, which came into effect in 2000. Basically, the problem was for scenarios such as, for example, where an individual is a life tenant under a trust, is occupying a property, and is also a trustee. In such a case, if the individual has lost capacity but has appointed an attorney under power, then in order to basically allow land or the house to be sold or dealt with in any way, it is essential that some rules exist that will allow it to happen without having to go to court. So this Section 1.1 of 1999 Act basically allows the attorney to act on behalf of the incapacitated donor, who is also a trustee, as long as that person has a beneficial interest in land. So the section was introduced to basically allow disposal of property, disposal of land. And actually it was interesting to look at the Hansard text from when the bill was discussed, because initially it only related to the land or disposal of land. And of course, the point was what happens if the attorney, it takes part in the transaction, receives the proceeds of the sale of the house, and then what can he do with it? So then the section was amended to include capital proceeds or income from land. So basically, in case of such a trust where you have life tenant who is incapacitated and also a trustee, but there is also an attorney acting on behalf of the life tenant, then such an attorney can then act as trustee. Typically, you will have more than one trustee. So if there is a requirement for all the trustees to be involved in the decision, for example, proceeds of the sale of the house are being invested on behalf of the trust, and then all the trustees need to make an application, and subsequently all the trustees need to deal with the investment. In such a case, the attorney can actually act on behalf of the donor trustee. So that's all for today. These are the only exceptions that are currently available. Some of you may have heard of an old exception for enduring powers of attorney, where actually it was possible for an attorney to act on behalf of the trustee. This was basically not very good drafting, which allowed this to happen. It was never intended, and it was repealed by the 1999 Act, and it applied to certain powers which were registered before 2001, but not since. So very occasionally, there may be such a case, but in principle, the general rule is that attorney cannot step into the trustee's shoes, except for those two exceptions to the rule. The first one is a delegation for up to 12 months where the donor still has capacity, and second is where it involves sale of land and investment of proceeds. Thank you very much for listening.